Good afternoon. My name is Marshall Drukarsh. I'm very, very honored and pleased to be joined today in this panel by Monsieur Jean Roberge, who is, as you know, the Director General of Operations for Immigration. Also, it's of interest to note that his background is not in law. It's in searching for the truth in other ways. It's in journalism and political studies. Mr. Roberge has had a distinguished career in public service and has clearly merited the position which he now holds. It's also my pleasure to be joined by Nancy Goodman. I'm a touch uncomfortable introducing Nancy because she is, after all, one of us. Nancy was a very active member of the bar and advocate for some of the same things that we are desperately concerned with, and has become a very, very significant and honored administrator for the Immigration Appeal Division in our region, and one whose influence is felt throughout the entire operation of the IRB. Our topic has to do with conduct becoming. The notes I scribbled before the previous panel said that everybody had been too polite and I would change it. Well, I'm going to be me anyway. To be a lawyer in Ontario, you have to start kindergarten, go through grade 13, get good enough marks to make it into university, spend at least 3, usually 4 years piling up debt to earn an undergraduate degree, 3 years or more at law school, learning the historic traditions of legal reasoning, learning precedent, learning case law, learning how law evolves and is made. You then slave for a year for a lawyer during your apprenticeship. You then go through probably the most vigorous intellectual exams, professional exams in the world for 6 months. Then you're a lawyer. You're governed by a strict code of conduct, which we're here to discuss today. To be an immigration consultant, you wake up one morning and find somebody who's willing to give you 5 cents for your advice. The Immigration Commission doesn't seem to see any difference. The operations manual that is part of your material describes the policy on practitioners, that is lawyers, consultants, and indicates that applicant representatives, that is lawyers and consultants, have a legitimate role to play in assisting persons who apply to visit or immigrate to Canada. All applicants should be treated equally, whether or not practitioners represent them. A personal failing of mine may turn out in some of you others to also be a failing. I personally believe it's a failing for me to be offended by the fact that immigration doesn't see the difference. I can understand from their perspective why there has to be no difference. I can understand from their perspective why they cannot appear to be favoring people who've gone to the trouble of hiring somebody who's trained and disciplined over hiring people over people who've either hired no one or who have amateur help or who have professional help without our standards. Having said that, I nevertheless do firmly believe that for our own sake, for our own dignity, for the importance that we have as lawyers in society, for the importance of the profession, that we must adhere to the standards of ethics that are laid down, that we cannot let ourselves slip back in the name of being competitive, in the name of chasing a dollar, to the standards that the government that we're dealing with is prepared to accept, the standards of being ungoverned, the standards of saying and doing whatever one wishes. There's an interesting article for those of you who are concerned with such things in the Canadian Bar Review, the March-June '97 edition, on the question of integrity testing for lawyers. The article points out that much has been written about legal ethics and professional responsibility. It points out things like the evil phenomena of the lawyer jokes. It points out, a variety of reasons why there's a public attack on lawyers. In our province, in recent years, it's more of an attack on professionals generally. Let's regulate doctors into being civil servants. Let's have a suspicion of anybody who sets themselves up to holding out a higher standard and treat everybody as technicians for what they bring to the specific task at hand. That seems to be the public trend. Nevertheless, what we do is significant. Obviously, you've had a full morning of people talking about rule by rule. It's redundant for me. I had all kinds of ideas about running through and telling you which of the new rules I think are significant to our practice. Being redundant's never stopped me before. Very quickly, Rule 1.03. Read what it has to say about integrity. Read what it has to say, and remember that these rules shall be interpreted in a way that recognizes that a lawyer has a duty to carry on the practice of law and discharge all responsibilities to clients, tribunals, the public, and other members of the profession honorably and with integrity. That pretty well says it all. The rest is detail. Duty to be competent, duty to provide a quality of work at a certain level. Some of the points that are of particular interest to our profession have to do with specifically practice at the IAD, the question of withdrawal. You'll note in the old Rule 8, I think it's in the new Rule 209, paragraph 9 or something, that one cannot withdraw in a criminal matter for non-payment of fees. Well, as the minister keeps telling us, as the government keeps telling us, as the federal court keeps telling us, being deported is not a criminal punishment, it's an administrative step. This is not a criminal process, and under certain circumstances it may be permissible for us to withdraw for non-payment of fees, notwithstanding the fact that tribunal regulations may put you into a situation where they treat you as bound counsel from first contact. You have to fall back on the whole issue of treating the board, treating the tribunal with courtesy. Yes, we advocate fearlessly for our clients. Yes, we advocate without any fear of future repercussions. Will they like me? Will they not like me? Will they take my phone calls overseas if I push for somebody harder than they want me to push? Sure, that's what we're paid to do to a large extent. But also, to be courteous means that if we undertake to appear on a certain date, we darn well better appear. If we undertake to file something by a certain time, we darn well better file. And if we don't, the fact that we're lawyers gets us no protection. We're no better off than consultants. We're no better off than professional consultants or amateurs. Unfortunately, we're worse off in the sense that we're subject to discipline. Somebody can drop a dime on the Law Society and put you through the nuisance of being investigated for the silliness of having said you were going to attend on a certain day and having a calendar mix-up and not attending, and that can be elevated to the kind of serious discourtesy that can cause professional problems. With respect to one of the comments made by Mr. Orkin earlier that brought about a certain amount of discussion, I support his view. In my view, a muck, something that you as a professional recognize as a manifestly unfounded claim, a claim to refuge that is not justified by the fact and circumstance, is something that you really ought not to put forward. And you find yourself in the position where you could be in breach of the requirements, because I view a PIF as an affidavit. It is something made under oath. And there's an obligation not to put forward false affidavits. There's an obligation not to put forward false evidence. There's an important distinction that was made in earlier discussions. It is, in my view, obviously true that where one has been sucked into the system, where one's rights are in jeopardy, that one is entitled to the services of a lawyer. One is entitled to have an advocate. But where one seeks to access the system, where one seeks to exercise a right which one is not entitled to, that the advocate has a responsibility to decide whether or not to take the matter and cannot knowingly mislead the person by taking on speculation without explaining clearly to the person that it's speculative, that they're not entitled to that which they seek, that there's a variety of problems in what they're doing, and without written instructions to the effect that you have instructed me that that which I am seeking I am not going to get. I am not entitled under the law. I insist on persisting. You have set a fee. It is not robbery. You have told me already that I'm paying you for nothing. And even then, you're going to have trouble defending yourself later as counsel. With respect to one of the other specific issues that arises in terms of right to counsel and whether the government could, if they wished, not deal with consultants and give us the respect that I started off pitching for us to have, I'd like to point out that at the moment in the Immigration Act, For an inquiry, Section 30 says that one may have counsel, which is a barrister and solicitor or other counsel. The Immigration Refugee Board, with respect to refugee claimants, Section 69(1, deals with counsel or other agents. Where someone is detained pursuant to Section 103.1, sub 14, they're entitled to retain counsel. At the Immigration Appeal Division, there's no right to counsel. The division is a court of record. The division could, in my respectful submission, choose to deal with barristers and solicitors, choose to distinguish how people will appear before them represented by other professional counsel. They have some authority there if they choose to recognize it. And in my respectful submission, the overseas offices have the obligations to and the right to accept communication from people and to communicate with people who are Canadian citizens or permanent residents in accordance with the operations memorandum, but not an obligation to do so, and not an obligation to engage in the process of discussion with them, and they too could, if they chose, limit who they deal with. It's a bit of a pipe dream to think that if we're good boys and girls and practice law nicely and follow all the rules, that they'll make the decision one day to only deal with lawyers. It's unrealistic. But we still, I say again, have an obligation and a responsibility to ourselves, to our profession, to the public whom we serve, and to the tribunals and agencies we deal with to follow these rules of conduct, which have been expounded at length this morning and which we'll discuss in more detail later. The original discussions that I had with my colleagues on the panel was that I'd do a brief introduction and a quick look at the rules of practice, and that then Jean is going to tell us something of the department's expectations for the new guidelines, and then Nancy is going to tell us something about the IRB's expectations of us, and then we're going to try to do a question period in which moderate questions on issue-oriented discussion topics will be entertained. Thank you. Jean?
Okay, I'll go next and say one thing, that when I retire, I don't intend to become a consultant. So that should be clear.
Me neither.
I was asked to speak about what the department expect of the conduct of solicitors. So I'll try to do that very quickly. Historically, we've seen a changing relationship between what I would call the CIC and solicitors. Past ideas have been us versus them. And when I first discussed that, I said, us, what has the US has to do with this thing? So they had to explain to me what it was. Second, we also went to a stage where we were looking for partnership, and at one time, immigration lawyers were part of the partnership environment that we had. Us versus them was often aggressive and confrontational, and in some cases, applicants were caught in between and maybe suffered in that case, and we certainly don't want that on both sides. And we also showed little flexibility on both sides. Partners was also very difficult to administer. There were different views as to what this means. Different level of access were given to solicitors by different offices, sometimes resulting in unequal treatment. The term partners implies sharing, and it was not clear what we were sharing, because sometimes we don't share. For example, we are not supposed to share information that is protected by the Privacy Act too lightly. You're not supposed to share information that is under solicitor and client privilege. So I think we left that behind us. We went to the current relationship, which is that we are two groups of professionals, and we have to interpret the Immigration Act and we have to interpret the regulation as they are. We may come to different conclusions sometimes on a set of facts or on issues, but we should do so and can do so in a professional manner that remains amicable. Many years ago, I served in New York, and one of my consideration there was with defense lawyers in the States. were often the same ones as that later became prosecuting attorneys, and they would be very, very, very much advocates of the sides that they represented at the trial. But after the trial was over, they were able to talk to each other and even have a drink with each other without being too personal, really, about things. So that's in my my history, I guess, with the department. This is what I strive to attain, that we have this kind of professional exchange. Somebody reminded me we don't have a judge in immigration that can separate both of us. So we have to be careful not to cross the lines. But at the same time, we should be able to talk to each other and explain our points of view. At the same time, some people have said that what we have today should be called, like the French-Canadian and English-Canadian relationship, the two solitudes, where the immigration lawyers are on one side and immigration officers are on the other. I don't share that, but that's one of the ideas. We do have things in common, I think. We should acknowledge that we share some values and some interests. We are both dedicated, I think, to the proper administration of the Immigration Act. And we both want efficient processing at our missions abroad. For us, this means that cases are processed as quickly as possible within the limits imposed by the resources we have, the physical and personal resources we have, and also by the need to ensure that the applicant is actually admissible to Canada. Often we have called this program integrity. What our expectations, what are the CIC's expectations when we get started? We think that you should tell us that you are representing a named client. Too often we have seen applications that fail to identify the solicitor, or that fail to authorize the visa office to release information to a legal counsel. This leads to delays and gets what should be a professional relationship up to a bad start. We also want to know what your client wants. At times it's difficult to determine what the applicant really needs. If you know that your applicant was previously deported, for example, and you're applying for minister's consent, tell us, because at times we won't guess what is required. We also want a clear instruction and requests coming for you. Some of you are old enough to will remember Dragnet on TV, where the sergeant always said, "Give me just the facts." And often that's what we want. Give us the facts of the application. By providing clear instructions and clearly stating what you want, we are better able to assess the application. We've discussed that here, you have discussed that before. We would expect that all your communications are professional and courteous. We don't think personal attacks upon a visa officer enhance the applicant's ability to qualify for admission to Canada. If an officer has made an error, it is appropriate for you to identify it, and we want to know it. And especially myself as a manager, I want to know the facts of the error. But again, I would want it to be said courteously, not implying that the officer was stupid or malicious for this. Well, one thing also is clear with us, we are not interactive. When you communicate with us, we are quite slow. We don't respond instantly. Many posts don't have the means or the tools to respond to email, for example. We're sometime in the dark ages in that case. We want letters, we want them to come in quite identified, and we want to answer them. But one thing that I insist on myself and that you should insist on is that we should reply within the standards that are often published. I think most offices now publish standard of application. We try from Ottawa when we need to produce certain timelines that should be adhered to, and we expect the officers to adhere to those. What is unacceptable conduct for us? I've said before, we think threats are not welcome. We don't think that an officer of the court should withhold information that benefits the applicant. We have seen that sometimes. If an applicant has a relative in Canada, there's a bonus in points. You should tell us that, because if it's not in the application, we don't know. And also, we don't want unprofessional communication and conduct. My previous posting was in India, in New Delhi. So I sometimes look at the internet, and you'll see on your binders that I look at the Hindustan Times, where it is said that an immigration lawyer in the States, of course, went into a rampage and killed 5 persons. What we say is that we don't see that as acceptable behavior. And I would also add it's bad for business, as somebody else said before. What can you expect from us? I alluded to that. You should expect from us equality, fairness, and impartiality. You should expect a non-adversarial relationship. So from our side too, we want to be courteous. We want to answer, as I said, within standard, and we want to tell you why we have reached to a certain decision. Call it clear explanations, as I have said. Within that relationship, what we can do is, for example, accept direct hospitality from lawyers and consultants. We have seen that in the past. Things have evolved. We say now that you should not, for example, try to take us to lunch. I might say for lunch here, but we'll have to see that. But when you go to offices abroad, this is one thing. It's not malicious again, but it is something where you put the officers often on a difficult footing. Also, we don't have time in many offices to meet all practitioners one-on-one. We try to do so as resources permit, but in most posts we can't anymore. So many posts offer group sessions where they will discuss changes in procedure or whatever that should affect all of your clients. And we urge lawyers and practitioners to take advantage of those group sessions. I had a rule when I was in the field that we would see people individually only if they had an organization that they represented. For example, if somebody was on the executive of the CBA and told us so and said that that's the conditions under which the person was coming to us, we would agree to see that person. But we would not discuss cases involving that particular lawyer. We said, no, we're meeting the CBA as an association. We're not meeting a particular person. So we encourage that. And finally, you have seen court decision on that. One officer, be it the manager, cannot fetter the discretion of another officer. We cannot alter a decision that somebody has already made, and that should be realized, I think, for this. My conclusion was that yes, I think the relationship has evolved over time. As I said, I've been around for quite a while, and I've seen it change through the years, through many ways. As I said, we will disagree, I think, on facts, on some case, and on issue, but we should do so amicably, and I think we can do so amicably. I heard many questions when I was sitting down. As I said, I tried to keep a low profile. I said nothing, but that's a good thing, I think, to have the exchange and be able to talk. We also encourage and we want two-way communication to avoid as problem as possible. We have recognized the value of meeting with the Law Society to discuss important issues. We also meet regularly with the immigration section of the CBA, and more recently with a smaller group and other practitioners to discuss, again, important issues. I co-chair, in fact, a meeting with Joan Atkinson when she was a Director General of Selection that involves the CBA, lawyers, practitioners. We call it the Immigration Practitioners Policy Operations Committee. So I call it the IPO committee. And I've been told there's no age, but I say yes, call it eye level. That will make everybody happy, I think. And we have, I think, a very, very good agenda. What you have in your binders, the OM, the communication we sent to Post about communications with lawyers and third parties came out of discussion at that committee. And we'll have the next meeting, I think, in September in Vancouver. We try to have it outside of Ottawa alternatively so that people have a chance to come in from outside, from other regions quite openly and talk about the issues. And the agenda is set jointly by the different parties. And we tried at every meeting to agree to the future agenda so that we have in-depth discussion of the issues. So we'll continue that. That's a conclusion of my talk. As I said, it's a few examples of what we do jointly. Thank you.
It's my turn?
Your turn.
Okay. As is true of almost every administrative tribunal, the conduct of counsel appearing before us significantly affects our ability in dealing with our cases and effective processing. So I'm really delighted to have an opportunity to address you on appropriate behavior which conforms to the rules of professional conduct, with really the goal in mind of presenting the tribunal's perspective and the ultimate goal really of an efficient and effective operation of the Immigration Appeal Division. I'm going to talk essentially about the Appeal Division, though many of the comments that I'll be making really reflect the views and the institutional concerns of the Immigration and Refugee Board and probably other tribunals as well. I guess the fundamental point to emphasize, and one that I think we're all clear about, but it's key, I think, to remind ourselves, and I think as an important message, is that although tribunals are intended to be more accessible and less formal than the courts, it's just as essential for you as counsel to treat yourselves as officers of the court when you're considering what your professional and ethical obligations are before a tribunal. I'm going to talk in a few areas. I'm going to talk about some of the basic expectations for those of you who haven't practiced a great deal before the division, but I'm not going to spend a lot of time on that. Give you a little bit of a sense of an overview of some of the problem areas that the board experiences with respect to issues of competence and professionalism, and then to talk finally a little bit about the board's direction in terms of dealing with some of these issues. As far as the basic expectations, just like every other tribunal, in addition to looking at the expectations as they're described in the rules of professional conduct, you look more specifically at the rules of a tribunal and essentially the rules of practice and procedure, such as the Immigration Appeal Division's rules, and the practice notices are critical for you understanding what your obligations are and what the expectations are. I'd refer you just quickly to one very useful article, which is by the Assistant Deputy Chairperson for the Appeal Division in Toronto, Paul Adderman, called An Introduction to the Jurisdiction of the Immigration Appeal Division. It's in 39 Immigration Law Reporter 2nd at 195, and it's a good way to get an overview. As you read the rules of practice, and you should read them, we do expect them to be applied and in fact treat them quite seriously with real consequences when they're not applied, but there are a couple that I'd like to highlight. Rule 13, which is the rule with respect to postponements and adjournments, and we have two practice notices that relate to those as well. The practice notice on postponements and adjournments, and another one called the scheduling of appeals. And essentially what we've done there is try in clearer terms than in the rule itself to alert counsel to what we consider to be appropriate behavior with respect to practice before the Appeal Division where it comes to postponements and adjournments. And basically we set out a pretty simple principle. You agree to a date before the Appeal Division. You agree to that either because you appear at assignment court or because you indicated that you don't need to appear at assignment court because you're ready to proceed. And so for us that means three things. You've made an explicit commitment that you are prepared to proceed, that you will appear and attend, and that you will not make other commitments which will make it impossible for you to do so. And then the standard for granting a postponement and adjournment becomes one of exceptional circumstances, having taken that into account. And I'd say that of all the areas in which we have the most issues that we've either complained to the Law Society about or that we've dealt with internally, it is counsel's failure to appear. And the consequences in many instances are proceeding without counsel. So there's serious consequences, obviously. The one other area to sort of highlight, I think, is disclosure. We have under Rule 18, the disclosure rules requiring 20-day disclosure of documents. Again, an area in which council often don't take it seriously, may have one or two documents, but often have packages of documents that even experienced counsel who are fully aware of the rule feel, well, they'll make an argument that in the interests of justice, that it would be too prejudicial not to permit those documents to be entered despite the fact that they're late. Well, if you're lucky, you may get a warning the first time you intend to do that, or you may simply be told that those documents are not admissible, because certainly there are other factors that are to be considered when the rule hasn't been adhered to. So again, it's something to realize that, particularly with respect to the Immigration Appeal Division, that we take very seriously. That including even when the minister consents to the documents coming in. And the member has to make a decision, may want to be in a position to have read those documents in advance so that they can be assured that the kinds of issues that they want to address in the hearing and want to be sure have been addressed are addressed. If they haven't had an opportunity to review those documents, then they also aren't in a position to ensure that there's going to be an effective functioning and a fair hearing. So those are the two ones that I'll highlight along there. I think that they're the most important. Talking about conduct of counsel, we have a lot of very competent and professional lawyers who appear before us, and yet we certainly also have a significant number of problems in the Appeal Division, and it's an ongoing and important issue for all of us at the Appeal Division. So I'm happy to do a little bit of an outline of those problems. The problems that we get run the entire gamut of issues that you would expect if you were to suggest what responsibilities of counsel should entail. So they go from incompetence, lack of familiarity with legal issues, lack of preparation and familiarity with the file, uncooperativeness, not only failing to adhere to practice notices and so on, but members' direction in the hearing room. I know that you've heard a little bit of the other side of what you have to do as counsel to properly prosecute your case and make sure that arguments are put forward, but we also have lots of experiences in which counsel clearly don't get the right way to do that, respect and decorum as well. And then also all kinds of examples of unethical behavior, whether that's misleading the tribunal with respect to evidence, to reasons for postponement, engaging in abusive process. I'll talk a little bit in a few minutes about withdrawing of appeals as a potential for abusive process, not respecting confidentiality of our processes. We also have an alternative dispute resolution, a process with guidelines related to that, principles related to confidentiality being part of that. To let you know that the IRB over about the last 7 years has had 25 instances in which we have reported counsel to the Law Society. The most significant, as I mentioned, being for failing to appear, having made a commitment to appear. The second most popular category, disrespect in face of the tribunal. And thirdly, abusive withdrawal from cases, lack of candor, disrespect out of court, false affidavits, or the other kinds of issues that we've raised before the Law Society. There are also very many more instances in which what we do is either by way of writing to individuals or more likely having usually the assistant deputy chairperson in the region speak to counsel, require them to come in and discuss their practice with them. We're looking towards some new initiatives with respect to dealing with issues around controlling our own processes and not just relying on the traditional concepts of practice notices and rules. And I think essentially we feel that now, particularly I speak for the Immigration Appeal Division, we feel we've gotten our house in order a little bit, that at least you can expect that you're going to hear your cases are going to be heard in a timely way, that you will get decisions either orally or, with almost no exception, written decisions within the 90-day time period. Our average processing time from beginning to end is at the moment 7 months. And also we do our best to ensure by way of show cause hearings that records are prepared within the 6 months that are required by our rules, so that we are now starting to look at some of the other issues with respect to individuals who appear before us and how we can better deal with making sure that the tribunal functions in a really effective and fair way. So we're looking at some more innovative approaches, some of which will relate more to consultants, but certainly some to relate to consultants and lawyers. We're looking for materials, training materials, for individuals who we feel, particularly consultants who don't really clearly understand our jurisdiction, think that perhaps since when it comes to incompetence, with the exception of gross incompetence, there probably aren't other easy ways for us to deal with those issues. We're in the middle also of preparing documents for unrepresented appellants, which could help underrepresented appellants as well. But the other areas that we're considering are code of conduct for counsel, and also hearing room processes, and I'll talk about a few of those to deal with some of the issues that cause us concern. In terms of competence areas, we've been involved, and I won't spend much time on it because it's consultant issues, but we did make our own submissions with respect to the regulation of unrepresented and underrepresented individuals to the Corey review, which Mr. Justice Corey's report should be out any day now with respect to the issue of regulation in Ontario, and the board certainly supported licensing and regulation together with more powers for dealing with counsel before the tribunal. In terms of the issue of gross incompetence, at least, in addition to reporting to the Law Society, there are a number of other approaches that our members are starting to take. And there's a recent case which concerns the issue of gross incompetence, and this does not involve a consultant, in which the member felt that the complete lack of knowledge of the law, which was being exhibited by the counsel, despite various indications by the member that perhaps counsel would like to consider other aspects of arguments in representing this case before the client. It was a case in which the counsel in new financial refusals was essentially relying simply on having met the low-income cutoff figures without any other, making any other submissions. In this particular case, the member has now requested submissions as to whether the representation of that counsel constitutes a denial of natural justice and whether the hearing itself should be quashed. So that's one approach we're taking. With respect to consultants, we're also looking at the Romanowitz decision. I don't know if you're familiar with that. It's an Ontario Court of Appeal decision, 1999, 45 OR 3rd at 506, and it doesn't deal with administrative tribunals, but it does deal with the criminal courts, and there was a question essentially of whether a trial judge could refuse a person who was not a barrister and solicitor as an agent to appear before them if they felt that to allow them to do so would undermine the integrity of the proceedings. So this is an avenue that might lead for some exploration in terms of controlling our processes. Finally, in terms of the issue of unethical conduct, in addition to, as I've mentioned, reporting counsel to the Law Society or calling counsel or consultants in to have discussions with respect to their behavior, there's some indication, well, there's a number of things we're thinking about doing. At the moment, we are going to be beginning to use the IED's contempt powers, although I tell you very frankly, we would prefer a far less formal kind of approach to deal with the conduct of counsel. There is some indication, particularly in a new case that I'd refer you to take a look at as well, which is Wilder versus the Ontario Securities Commission. It just came out, and it's 47 OR 3rd at 361, and it was a case in which the Ontario Securities Commission was looking at conduct of counsel, and the Law Society said that was completely within their own ambit, and the court said no, that Law Society doesn't have the exclusive authority to ensure that individuals do not mislead the tribunal. Now, there's some very, I think, certainly distinguishing features of that case, but there's an indication in the direction of administrative tribunals controlling their own processes. But at the moment, at least with respect to the board, we do have our contempt powers, and we have a case at present in which we're considering using them where an individual has prima facie repeatedly and knowingly misled the tribunal with respect to their availability, the requesting of postponements, and so on. And that, if the case were to proceed, we would get to a point where it would be determined whether the counsel would have to show cause as to why they shouldn't be held in contempt. The IAB did this in one case some time back. But before it got to actual determination, the counsel who was involved voluntarily apologized and suggested that he wouldn't appear before the board at that time for 3 months. So this will be the first time that we may, and we don't know what will happen, obviously, in that case, but we'd like to do something a little bit less serious than that, but again, it is a serious matter, and it seems that in terms of the processes that we can use, it's best that for now we continue along that kind of line. Finally, in terms of abuse of process, another concern which we intend to deal with somewhat more strongly than we have in the past, and I refer to another interesting case. The case is Kolati. It's Yaspal Singh Kolati versus Minister of Citizenship and Immigration, and it's a March 13th, 2000 Federal Court of Appeal decision of Dikari. The docket number is A52698, and even though it was originally a res judicata question with respect to the appeal division and whether a refusal on a marriage case could be reconsidered a second time, essentially the court didn't treat it as res judicata. It looked at the issue of abuse of process. And again, speculated, there was suggestion that administrative tribunals may have their own powers to control their own processes fundamentally, but the court didn't need to deal with that with respect to the Immigration Appeal Division, because under 69(4) of the Immigration Act, as a court of record with the powers of the Superior Court, the justice acknowledged that the Immigration Appeal Division has jurisdiction to control its own process and to prevent its abuse. And again, it's not that this is something we intend to use every day, but we have, for example, instances in which a counsel will be 3/4 of the way through a hearing and feel that the evidence as it's coming out is not going to lead to a positive result for the client, and rather than continue with the case, abruptly thinks that they can simply withdraw so that they can reapply. And so in those kinds of instances, we certainly would think that it would be appropriate for a member to consider whether the withdrawal should be permitted and whether that would be an abuse of process. So we're exploring all of these different avenues, potentially with the going towards the possibility of a tribunal-wide code of conduct, but also particularly, and the Appeal Division's taken a bit of the lead on this, but particularly because in the proposed new Immigration and Refugee Protection Act under Bill C-31, Section 158(1) of that act says that, subject to the approval of the Governor and Council and in consultation with the deputy chairpersons, the chairperson may make rules respecting the conduct of persons who appear before board and their council. So that clearly gives us a possibility of trying to be able to indicate some of our expectations and the kinds of consequences that failing to adhere to those expectations will bring. So I'm sure I'm getting at my time limit. I hope that I've given you a little bit of a sense of some of the issues that cause us a concern. I'm delighted to be in front of a group of people of whom I would certainly not expect that many of those issues are your issues. It's precisely because people like you come and are concerned about ethics that you're here for that reason today. But I think it's important that everybody be aware of the kinds of concerns and really to pass some of those along to your colleagues in terms of sharing the expectations that people have. And I thank you for your time.
Questions? Yes.
I got three. I wanted to ask Nancy, first of all, at times you can end up with quite an adversarial relationship with a board member.
Mm-hmm.
And I think what the board is doing in terms of taking steps to have codes of conduct is important. And so I guess the concern I have, though, is there not a danger that it will adversarialize the relationship between the board and the bar? Because I think bad board members, or not just board members, can't use it to harass counsel. That's one concern. The second is, have you had discussions with the federal adoptions, if it's a genuine relationship, the board has destroyed the family's life. And I take that very seriously. But what I'm finding now is that people are beginning to sneak the kids in and do adoptions under Canadian law. That doesn't serve the board at all if there is not a process to have these cases looked at properly. And I don't think there is at the moment. I think it's a complete misunderstanding of cultural dynamics in different parts of the world that leads to all these refusals. But you know, there are sort of human rights involved in terms of family integrity, and to sort of say it's an abusive process because they want to try and keep pursuing bringing their own kid to Canada, I don't see that as abusive. And what concerns me is how you dealt with that case.
Yeah.
That's what's going to happen when we're talking about very similar relationships.
Okay, I'll start at the end. In terms of the issue of adoptions, I mean, you raised a couple of different things. In terms of your criticism of how the board handles those cases, one of the things that I mean, you know, it's a tribunal in which we make decisions on the basis of the evidence before us, and if you think we're not taking proper cultural norms into account and that we're misunderstanding what the context is that the best thing you can do is get a concerted effort to put those kinds of arguments on the record so that they can be determined, and if they're rejected, then you can deal with it. I mean, this is, you know, it's an independent body, and that's sort of the way that you're going to go there. In terms of my comment about Kolati, and just to put it in context, I'm thinking about there have been very few instances in which I would suggest that we would be using that kind of approach for abusive process. But if you got 3/4 of the way through a hearing and it was clear that there was no evidence of a relationship in, you know, from the appeal division's perspective, and again, if you have other arguments as to why the appeal division shouldn't concern itself with the fact that they have no knowledge of the child or no contact with the child, then that's an argument that you have to make. But if you were to take the jurisprudence that exists now, and there's no evidence of that, and a board member realizes that the person says we're going to withdraw that appeal and has a sense that they're going to do it because they want to help that individual to then next time say that there is evidence of relationship and so on, then I think it would be completely inappropriate for us not to take that responsibility. So I don't see it, I mean, I'm telling you some of the things that we're beginning to think about. I'm not thinking about them by any means as an aggressive and ordinary way in which we deal with counsel. I think it's a very fair comment, but I'm just coming here today to tell you, well, you might hear that that will happen once or twice. In fact, in terms of some of the issues that members have raised, I mean, we've made very clear to them, for example, in this issue of whether we decide to use our contempt powers, which we do not want to use, but we're very unhappy with a lot of the representation that we get before the appeal division and the kinds of problems that we have to deal with. So we need some remedy to ensure that people are taking the processes honestly and seriously, which is all we're talking about. So we've said to members, though, we're looking at one case. This isn't something that members are encouraged that they individually can do in any event. Members are not doing that in any event. So, you know, I think fair comment, because I'd be happy to answer back that I don't, if I'm giving the impression of being that aggressive, it's not that aggressive. We don't intend it to be. But on the other hand, we do intend to tell people that they should take us seriously, because certainly we have lots of instances in which people are abusing the process, and I'm sure you all have your own stories and are aware of those as well. Just quickly on the other points, no, we haven't dealt with the federal court in terms of how they should be dealing with their cases. It would be very helpful to have a broader view of competence of counsel. I mean, we're very frustrated, as I said. It's clear that probably other than gross incompetence, the best we can do. I mean, we have board members who want to put training materials together to get consultants to come in and understand what our jurisdiction's about. Now, that's not our job, but certainly when we're concerned about people's representation before the board, we're going to do that. So, I mean, you know, we spoke to Mr. Justice Corey. We'd be delighted with there being education of consultants and so on. And in terms of the concern, the first one, which had to do with, again, rules of conduct in terms of harassing counsel, I don't think, again, we're not looking at a process in which a board member simply in the middle of a hearing says that behavior is inappropriate. And we've got we're pretty careful about how we proceed in any event. So, I mean, you wouldn't get someone doing that without having minimally a manager listen to the tapes that were related to it and so on. But again, what we're trying to do is say at the moment, there are no consequences. We're looking for a consequence which in the extreme case, of which we do have some, we could comfortably say, cool it. 2 months, and you're not going to appear before the appeal division. We're serious about it, and you'll come back. We're not talking about individuals who, aggressively pursue their cases for their clients. And I know you have to trust us on that, and I can see that if I were counsel, I wouldn't be that confident either. But from our perspective, we have a job to do too.
I saw Gary's hand about the same time as Barbara's, and then there's a gentleman in the center at the back. Yeah.
By a senior officer.
Mm-hmm.
That's very different than a negative decision, a positive decision, then made negative, as opposed to a negative decision made positive. It's a totally different kettle of fish. It seems to me that what the court was saying in those cases was that, and by the way, common law, administrative law has always said that a negative decision, a decision that goes against whatever the application, can be reversed and made positive because it's in the best interest of the individual. And yet this has been totally taken out of context within the immigration department. So what you have are, negative decisions. You then approach program manager, senior person, and say, I'd like to review this because I think the person's made a mistake or this document is a positive decision. You say, oh, we can't better the discretion. That's wrong. And I think it has to be corrected. I think it has to be pointed out that a negative decision can always be overturned by a senior officer what is he sitting there for, or he or she's sitting there for as a program manager? Are they sitting there just to count the number of cases to go through and the number of paper clips that they've ordered that month? Or are they there, in fact, to review the work that's being done by officers and go in and say, I think that's a wrong decision, I'm going to reverse you?
Good.
That's what they're being paid the big bucks for.
Good question. John?
Yeah, I don't order any paper clips I know. I would agree. The manager to me has a duty when you're citing a mistake. The mistake has been committed. The manager has to go back and look at the case, and if there was a mistake, the correction should follow. And that's to me the role that the manager has to have. Often when we talk about fettering, it's more that there has been no mistake, but there's a disagreement on the facts of the case. And that's where I say the manager should not go down and change that decision because there was no mistake committed, but there might be a difference of interpretation really of what has been done. In my practice in the past, what we have said is that if the decision is really, really wrong, then we have to correct it. If it is a matter of that is not a mistake, a new application has to be submitted. You cannot force the officer to change the decision, in my view. But if there is a new application with new set of circumstances, the same decision might not necessarily come.
There was a gentleman in the center at the back that had his hand up, and then a gentleman a couple rows forward.
It's doing very well. Doing a little ad, I can do a little more than that. But we've been really pleased with the fact that we've been able to take a lot of cases out of an adversarial process and have people resolving cases without having to go to a hearing.
So you have designated cases. I mean, you have
We have a whole, we have a series of guidelines which relate to the alternate dispute resolution process as to which kinds of cases can be considered under it and not.
and you have no plans to expand it.
ADR is
It
expanding
is.
across
Well, Marshall
Canada,
can- yeah.
which tells you that it's obviously been a success here, because if it had fallen on its face, it wouldn't be expanding.
We introduced it into Vancouver. It's been going in Vancouver for a couple of months, and eventually we'll be introducing it in Montreal too.
There was a gentleman here.
Two questions for Mr. Roberge. First of all, how is it possible to visit a
On the first question, as I said, we have encouraged that from the headquarters side. If there has been a mistake committed, if there is an error in the handling of the case, the managers wants to know and should want to know. So if there is an office that is not interested in error in fact, I would say let me know in Ottawa and we'll look into it because we want that issue to be addressed. Again, I will always underline there's often a dispute or a disagreement within what's a mistake and what's an opinion, and that's what we sometime will have to come with a clear decision on our side and say, listen, you think it's a mistake, I don't think so, that's the end of it. But the manager should look into that, and I would say myself, in my experience, talking with a lot of our managers of larger posts, they want to know. That's often the way that they can actually kill problems before they become more difficult to manage. So they want to know that. Again, if you don't have an answer from an office, if you think you have an urgent matter, there is at least one official route to go to. In Ottawa, we have a case management division where they have a desk for every region of the world. And if it's a case-by-case issue, they are supposed to handle those. If it is a what we call quality of service kind of issue, then it should come to me again, to the international region of CIC, where we are not mandated to look at a case for case reason, but we're mandated to look at issues of, as I said, of quality of service or lack thereof, I guess.
Couple of things, if I may. I recognize two persons, the end of the second row and the gentleman in the front row, had their hands up before we said we were ending questions. A small commercial. There are evaluation forms in the package of material. Please fill them out. It helps us in the organization and presentation of other programs. If we don't have your assistance, we don't know who's effectively communicating or whether we're serving your needs. When we do break, the return will be at 1:45 for workshops. I'm sure that you've all figured out which workshops you're in and where you're going. There are staff outside, I hope, Howard, who will help you if you need help. I'm pretty useless. I have a sheet here, but don't ask me. I can't read. And as I say, there was a question from the second row here.
But now you have to remind you that, as we remind everybody who appears before the Immigration Appeal Division, that Ministers' Council are citizenship and immigration employees and have absolutely nothing to do with the Appeal Division except that they appear before us. And we're completely aware how, in many instances, how critical that the availability of Ministers' Counsel are to all our processes. And I think, you know, from having been counsel 20 years ago and had certainly a clear sense that being able to resolve cases without going to a hearing was one of the fundamental things which would make the whole system work better. It was for that reason that the IAD decided it needed to be institutionalized, because it is a shift in perspective. There are differences in views in different regions in terms of CIC's comfort with being able to do that. I mean, they represent the public interest. They should be able to recognize, and it's one of the fundamental principles of ADRs, their obligations are not adversarial obligations. They're obligations which are to the public interest and essentially should be to resolve cases that should be resolved, and particularly those who don't need to go to a hearing should be resolved in a more effective way. And so what we've done, I mean, it will take some time. We started with Toronto, we then moved to Vancouver, and we will eventually, when we move to Montreal, Ottawa is part of the Montreal region, as you know. In terms of dealing with cases, we certainly have absolutely no objection, and in fact would be delighted to see any cases resolved, whether or not we have an institutional ADR process or not, but really you have to do your work through citizenship and immigration, and I know that that doesn't give you very much of an answer, but essentially at this point, I mean, we're not in a position yet to be able to institutionalize it. When we do in that region, then we hope, as with all the regions, it's a very slow process to have people take a different kind of perspective than they've taken for a very long time, and a role that a lot of people are more comfortable with. I mean, an adversarial role is clear. You know, you make your arguments and that's the end of it. You don't have to take on the additional responsibilities, which in ADR for a minister's council are closer to being a decision maker. Yes, I mean, a board member has to approve it and keep sure that there's institutional integrity, but it is a significant shift, and I can understand your frustration. We can maybe talk a little bit later about whether I've, any ideas about who you might speak to.
And the,
But integrity and coming for, complying with the rules of the board, complying with the timeframes and not seeking unnecessary adjournments and getting the documents in time. And, the lawyers are doing that and they can get some instances of reciprocal courtesy, which are mandated by the rules.
Right, now, if there are problems, so you're also saying it's not just ADR, it's that ministers' council are getting postponements that you wouldn't get for.
They're not doing anything. They're not complying with the rules. And it's not
Not complying in the rules in the sense that now often they don't have documents to disclose, so it wouldn't be disclosure rules. So I'm just trying to get a sense of what rules they're not complying with, because under the rules, they don't have to talk and resolve cases in advance of a hearing. I'd love to hear that that was happening, but they don't have an obligation to do that. So I'm not quite clear.
perhaps that
Yeah.
is a matter that's a regional difficulty that you could best get into a more frank discussion later. There was a last questioner recognized. Thank you very much, ladies and gentlemen. Enjoy lunch. 1:45 for the seminars. I wish I could be at all of them. They each sound good.